Welcome back to Court TV, where we're about to commence coverage of a murder case from Massachusetts that has become something of a cause célèbre both in Massachusetts and in the United Kingdom. 19-year-old Louise Woodward, an au pair working in Cambridge, Massachusetts, is charged with the first-degree murder of Matthew Epon, an 8.5-month-old child for whom she was caring. The death of Matthew took place February of 1997 this year, so this is a speedy trial. Right now, the judge is giving some preliminary instructions to the jury. The sound quality isn't great when the judge speaks to the jury because we only have a limited number of microphones in the room. So while he's doing that, let me introduce you to Kurt Flehinger, who is our guest today. He's an attorney from California, where he has practiced, and where, in fact, you were saying earlier you had tried a shaken baby case. And I hate to use that category, but certainly we talk about cases where young children die of brain injuries as shaken baby cases. What is it? Is there a special emotional context to those kinds of cases?
It's a very difficult kind of case to handle because you can't help but have a tremendous amount of empathy for the victim, the baby, and the parents. And at the same time, you have to convince a jury to divorce themselves from that emotional impact and to look at what happened to the baby.
Probably especially tough for the defense, which faces the natural protective feelings we all face towards children on the part of jurors who are sworn to evaluate the facts but must start off with some feelings about the case.
Very true. It's very difficult to get them to that place of neutrality to begin the trial, because if you don't start at that place of neutrality, it's very difficult to see the evidence in a fair light.
Must make jury selection very complicated. I mean, just to forget about all the other issues in the case, you've got to find people maybe who aren't unaffected by it but are sufficiently in touch with their feelings to be able to talk honestly about it.
And I think that's the point. I think a lot of times the misperception is that you want to look for jurors who are completely detached from it. And I think that's not true, because most jurors aren't detached. If they tell you they are, that's not really the truth. You want somebody who has wrestled with it, who has said, I have these feelings, I understand what it's like, the humanity involved in this, and yet I can put that aside and I will attempt to be fair. I think that's a more honest juror, and that's the kind of juror as a defense attorney and as a prosecutor you look for.
And then, of course, there are some of the other more traditional kinds of things you take into account. In this case, yet another special issue. The defendant is a British subject. It's being tried in Cambridge. There are movements in the Irish communities in that area, some of which are connected to events in Ireland and affect feelings about the British. That too a factor that might be taken into account in jury selection.
Yes, and I think that it's something that the defense lawyers in jury selection really need to get at, and it's a difficult thing to get at, particularly in today's day and age when jury selection is conducted so quickly. This jury was picked in a day. So the defense and the prosecution don't have a lot of time to ferret out what are really some subtle issues.
On top of that, I've been in Boston several times over the past year when stories were in the paper, and the coverage of this case has been unbelievable in terms of lots of people knowing something about the case, which is always frightening.
Yes, and it's difficult. But again, I'm not so certain that you want people necessarily who've never heard of the case. It's similar to the World Trade Center bombing case. When they picked jurors who lived in Manhattan who had never heard of the World Trade Center bombing, you either question whether they're being honest or whether they're so detached that maybe they're not the best jurors.
Now, going back to the question of trying to find jurors who don't have powerful feelings about children that would overcome their ability to be fair. We've often debated in trying these cases whether you want people who work with children or not. Certainly a mother who works with children will know that, for example, children can be challenging, but that cuts both ways, because the more you know that you can be frustrated about a child's behavior, the more you know it's possible that a person might overreact. So it's a really complicated and fine line, and there's no automatic good or bad answer.
No, and a lot of it will depend on what your defense is going to be. If the defense is really going to take a position that this was an accident, then you might be looking for just the juror you're mentioning, that juror who understands how easy it is to cross over that fine line and do something impulsive, non-intentional, that leads to a terrible accident, versus possibly having a defense in which you're saying that there was a pre-existing condition caused by maybe some kind of abuse by the parents. So it really depends on your defense.
That's true. And in this case, we don't know a lot about the defense. The defense has chosen not to talk to the press, perhaps understandably in a case with a lot of scientific proofs and where there's been a lot of publicity. I don't know whether Judge Sobel, who's the presiding judge, ordinarily gives a lengthy instruction at the beginning. Some do. but in a sense, that's a way of trying to condition people. Whatever you thought before, you start with a clean slate with a tilt against the prosecution because of reasonable doubt, the presumption of innocence.
Yes, and you hope that the judge, as a defense lawyer, and I think as a prosecutor too, you really hope that the judge gets that into the jury's mind beforehand. So you start with a clean slate. And like you said, the clean slate starts out with the presumption in favor of the defendant. And that's difficult to do.
I like the language of cloaked with the presumption of innocence. But as the judge describes the cloak, let's go inside so we can hear a little bit of his instruction, which I think will be followed by the opening statement of the prosecution. Let's go now to Cambridge, Massachusetts.